everybody, welcome to Learn with Steph. This is one of the videos as part of our Lessons in Law series. The focus is on OCR A Level Law, but it will be useful to anybody studying law. If you like the videos, please do subscribe and press the like button at the bottom. Hello, so this is the second video on actus reus. In the previous video, we looked at conduct and consequence crimes, voluntary acts and omissions, and state of affairs crimes. Today, we're looking at causation. So first of all, what does causation mean? Well, it's the link between the crime and the conduct. So in other words, this is for result crimes or consequence crimes. It links the defendant's conduct to the consequences. And you have to prove two types of causation in a consequence crime. You have to prove factual causation using the but-for test and legal causation using the more than minimal test. So factual causation, the but-for test. The question is, but for the defendant's conduct, would the consequence have happened? And if you're explaining this in an essay or a piece of written work, you always have to use the phrase but for, the legal test word. So using the case R.V. White to illustrate, this is where a son tried to poison his mother, but before the poison took effect, she died of a heart attack. So in this case, factual causation was not proved because but for the poison, she would have died from the heart attack anyway. The type of causation is legal causation. And we test this using the more than minimal test. And R.V. Kimsley, which was a case involving speed driving, basically, held that there must be a more than slight or trifling link. So that's a link between the defendant's conduct and the consequence. A more than slight or trifling, more than minimal. And the point is, nothing within the chain of causation to break it. So first of all, looking at the thin skull rule. And the case for this is R.V. Blau, and this is where a Jehovah's Witness refused a blood transfusion. And the thin skull rule is all about taking your victim as you find them. So if your victim has a physical vulnerability, perhaps a thin skull, and you hit them on the head and that crushes their skull, you have to take the victim as you find them, including their thin head. And in R.V. Blau, this rule was extended to include religious beliefs. So you have to take your victim as you find them, including their religious beliefs. The second part of this slide is R.V. Cheshire, sometimes known as the chip shop case. And this involves when medical negligence breaks the chain of causation. And basically, medical negligence will rarely break the chain of causation, and certainly not if the defendant is still the significant cause. So in other words, if the doctor is treating the original injury, and they do something wrong, then the chain of causation will not be broken. So the doctor's negligence must be independent from the act itself. The other two tests are third-party intervening acts and when the victim intervenes. So there are rules related to when this might break the chain of causation. So third-party intervening act. So in other words, when a third party does something and the defendant might claim actually the cause of, let's say, their death wasn't me, but a third party's action. And in R.V. Paget, the defendant was holding his pregnant girlfriend as a human shield, and he shot at armed police. The armed police shot back at him, and they shot the hostage. Now, obviously, the but-for test, so the factual causation, but for Paget shooting at the police, they wouldn't have shot back and killed the girlfriend. So factual causation is proved here. But did the police cause the death of the girlfriend, or did Paget? And here it was decided that this would be judged using a reasonably foreseeable test. And the question is, was it reasonably foreseeable that if you shoot at police, they will shoot back? If you shoot at armed police, is it reasonably foreseeable they will shoot back? And if so, then there's no break in the chain. So does the third party intervening act, is that a reasonably foreseeable consequence of the defendant's actions? And then victim's own intervening acts. And R.V. Roberts here is often is used to illustrate escape cases. So when the victim tries to escape, for instance, you set light to a burning building, and the victim then tries to escape by jumping out of a window, and breaks their leg. So is the person that set fire to the building the cause of the broken leg, or is it because the victim jumped out of a window? And R.V. Roberts here would deal with this. And again, the question is reasonably foreseeable. So was the victim's actions a reasonably foreseeable consequence of the defendant's conduct? And in the burning building, of course, it is reasonably foreseeable if you set light to a building, anyone inside might try to escape and injure themselves. And in R.V. Roberts, she jumped out of a moving vehicle to escape a sexual predator. And the point of law was, is it reasonably foreseeable that a girl might jump out of a moving vehicle to escape a sexual attack? And of course, the answer to that would be yes. Therefore, there's no chain of causation that is broken. So legal causation is there. Let's look at these principles of factual causation, the but-for test, legal causation, the more than minimal test, and those rules, so thin skull rule, medical negligence, and then the reasonably foreseeable test for a scenario. So this scenario is an old AQA scenario from an old specification. So Amir saw Carla, a teenager, whom he knew was easily frightened. Amir offered to give Carla a lift home in his car. As Amir sped off down the road, they discussed The Prisoner, a television program which they both liked. Amir suddenly said, "Now you are my prisoner." Carla immediately panicked, opened the passenger door, and jumped out of the moving car. Carla fell and hurt her wrist. When she got home, her wrist was very sore, so her mother took her to hospital. She was treated by a doctor who incorrectly put her wrist in a splint. As a result, Carla suffered permanent damage to her wrist. This permanent injury would not have happened, if she had been properly treated. So first of all, what key sentences in that scenario would you highlight to do with the principle of causation? Just give you a couple of minutes to think about that. First of all, we know Amir knew Carla was easily frightened. So Carla is easily frightened. So in other words, she is vulnerable. She has a vulnerability. Now, of course, it's not a thin skull here. It's that she's quite anxious. What was the consequence? We would always need to identify the consequence. And of course, we know she's hurt her wrist and she's also suffered permanent injury. So the question is, did Amir cause the hurt wrist, and did Amir cause the permanent injury? Or perhaps it was because Carla jumped out of the moving car. So perhaps it was a victim's intervening act. Perhaps that's broken the chain. Or perhaps because the doctor incorrectly put her wrist into a splint, perhaps that also broke the chain. So perhaps medical negligence broke the chain. So for this scenario, first of all, of course, but for Amir frightening Carla, she would not have panicked and jumped out of the car. So factual causation is proved. She wouldn't have hurt her wrist had Amir not frightened her, and she wouldn't have had to go to the doctors, and therefore would not have had permanent injury. So but for causation, so factual causation is proved. Secondly, the question is it reasonably foreseeable if somebody is really frightened, they might jump out of a moving vehicle? And the answer to that is yes. So the victim's intervening act, so Carla jumping out of the car, would not have broken the chain in this scenario. Secondly, he knows she's easily frightened, but anyway, perhaps he might argue that a normal person, if you like, would not have been so frightened, wouldn't have taken him seriously, and wouldn't have jumped out of the car. Well, the courts will say, bad luck, R.V. Blau, Amir, you've got to take Carla as you find her. You've got to apply the thin skull rule. And then finally, the doctor, was he to blame? Well, we know R.V. Cheshire said medical negligence rarely breaks the chain of causation. And the question is, it will only break the chain of causation if it's independent from the defendant's act. Well, the doctor was treating her hurt wrist, the hurt wrist caused by the jumping out of the car. So he was treating the wrist. It wasn't independent from the act. Therefore, it doesn't break the chain of causation. Therefore, Amir will not only be liable for the hurt wrist, but also the permanent damage. Causation is proved. The next lesson will be on mens rea. If you found this one useful, please press like. Feel free to leave a comment and I'll try and get back to you. And do subscribe to my channel so you get more lessons. Thank you for listening. That brings us to the end of this lesson in law. I hope you enjoyed it. If you did, please like it and subscribe to find more videos. Bye.